thanks to the PIJIP project for inviting me. Assuming indeed that this treaty will be carried forward, how could we improve it in such a way that it does the least harm, or more positively, that it's simply a better treaty for all parties concerned? So here's an outline of my talk. Let's first have a look at the current status quo. Where are we in the discussions and what has happened in the past? I will then summarize the current chair draft. I will summarize the main problems with that draft, not only expressed by me, but by many others. And then I will propose a number of amendments that, in my view, could address these issues. Where are we with the WIPO broadcasting treaty? Well, it's certainly not a new thing. It has been on the agenda of the WIPO SCCR since 1998. So shortly after the Internet treaties, the initial two were adopted. There has been, from the very start, rather stern opposition in many circles, civil society, stakeholders, also from the copyright and neighboring rights holders community. There has been strong opposition against granting an extensive set of so-called neighboring rights, special rights to broadcasters. For a long time, nothing happened until in 2007. The WIPO General Assembly intervened and ordered the SCCR to continue discussions, but with a much less ambitious mandate to focus simply on protecting broadcasters against signal piracy, against unauthorized retransmission of the broadcast signal. Additionally, the Assembly instructed the committee not to draft treaty language that would grant any so-called post-fixation rights. From then, this more narrow mandate determined the shape and size of the treaty. At least that's what should have happened. Now, fast forward to 2023. There will be yet another SCCR session. On the agenda of that 44th session, again, features prominently the broadcasting treaty as the first substantive issue. It's number 5 on the agenda, but everything before that is administrative. So it still occupies center stage in this important committee. On the agenda will be the third revised draft. The third revised draft is a relatively minor revision of the second draft, which was discussed, if I remember correctly, in March of this year. The comments paper that was published earlier this year refers to the second draft, but much of the critique actually still applies. Here's a summary of what the draft broadcast treaty looks like in its current shape. This is a chair text. It does not reflect any official consensus. It has not been officially endorsed by any WIPO member, but we are currently moving towards possible finalization. So it is an important draft, and it should be taken seriously. Like any treaty, it starts with a couple of definitions. We'll come back to some of those. There's some language on the scope, on national treatment, on reciprocity. I propose we not discuss that today. What is more important is the set of minimum rights proposed to protect broadcasting organizations. Interestingly, the more recent drafts, including the third draft that we're now looking at, does allow contracting states to deviate from that minimum rights model by offering adequate alternative protection against signal piracy, but only subject to notification. So that's more or less an exception to the rule of minimum rights that the current draft mandates. Then there's an extensive provision on limitations and exceptions. We'll talk about that too. And the usual stuff on technical protection measures that I propose we skip. Finally, there is an interesting optional provision that allows some formalities indicating that we're not looking at a copyright instrument here, but at a more neighboring rights type of regime. So what are these minimum rights? Obviously, the core of the proposal. The current draft proposes a handful of minimum rights, rights that all contracting states must provide if this treaty becomes adopted and if it is ratified. First and foremost, an exclusive right of retransmission, an exclusive right. This is IP language. And on top of that, a right to control fixation. We'll talk about both. In addition, there's a right to prohibit retransmission and fixation of so-called stored programs. That's Article 8, which is intended to protect broadcasters against the unlawful access to retrieval systems that store broadcast programs. Think of catch-up services. Many broadcasters offer these days. And then there's a right to protect so-called pre-broadcast signals against unauthorized retransmission and fixation in Article 9. Pre-broadcast signals are programs that have not yet been broadcast to the general public. So they're on their way from the studio via satellite, perhaps, or via the internet to a broadcast transmitter. So a bunch of rights, all required if the treaty becomes reality. However, introduced only a few drafts ago, is an optional alternative for those states who do not want to provide minimum rights of the intellectual property type. There is the alternative of opting for an alternative protection, provided that alternative offers adequate and effective protection to broadcasting organizations in line with Articles 6 to 9. This is Article 10, giving contracting states a lot of freedom to choose the kind of regimes they like. So if they go down this road, they need to notify the Director General and explain what this alternative will look like, what kind of legal redress the state will apply. Copyright, perhaps, telecommunications law, cyber law, criminal law. There's a multiplicity of possible regimes. Interestingly, if you look at where we are now with the treaty and where the consensus lies, this Article 10 much better reflects the current consensus amongst potential contracting states, amongst my WIPO members represented at the SCCR, than the much more extensive, more ambitious, much more far-reaching, much more traditional minimum rights approach that the treaty originally emphasized, and which still dominates the paradigm of the treaty. Look at the summary of the chair after the most recent meeting of the SCCR, which basically states that there is at least a consensus amongst the SCCR members that any potential treaty should be narrowly focusing on signal piracy, and that it should provide member states with flexibility to implement obligations through adequate and effective legal means. And there's also a common understanding, says the chair, summarizing the last meeting, that the object of protection of any potential treaty should be limited to the transmission of programs carrying signals and should not extend to any post-fixation activities. There is consensus about making this into an anti-piracy treaty that protects broadcasters narrowly against unauthorized retransmission. This is what they need to defeat the internet pirates. They don't really need that much more. And member states could do that in any way they like. This is what Article 10 basically states. This is not what Articles 6, 7, 8, 9 of the current draft provide, which is a much more broad-ranging, extensive proposal to give all sorts of rights to broadcasters. That rights-based approach on which the original idea of the treaty was founded and which still dominates the way the current draft is crafted is not called for in light of this much more narrow ambition. Signal piracy indeed can be combated with a whole range of legal means and does not necessitate at all the grant of any special rights, let alone any exclusive property rights of the type that the current draft contemplates. Signal piracy can in fact be deemed unlawful already under current law in many countries, under a whole variety of existing regimes. So there are lots of different means of protecting broadcasters. That doesn't have to go by way of an IP regime. Although discussions at WIPO very often automatically are about grants of exclusive rights, about IP property rights, strong rights. We do have some precedents that indicate that a treaty can be much more flexible than that. And two famous examples are on the slide here. In 1971, the Geneva Phonograms Convention was adopted, which has as its sole aim protecting record producers against record piracy, which in those days was rampant. So member states were obliged to take adequate measures to prevent the unauthorized duplication of records. But the convention doesn't mandate any minimum rights, does not even use the vernacular of intellectual property. And we see the same with the other WIPO treaty, the Brussels Satellite Convention of 1974. Again, an anti-piracy treaty. Again, no IP language, no minimum rights. Why don't we do the same here? I have a quote here, by the way, of no one less than Mihaly Fixor, for many years the Assistant Director General of WIPO in charge of the copyright and related rights agenda, who was the author of the official commentary to all the WIPO treaties that are now in the books. Satellites Convention, which was adopted in 1971, may also be regarded as an anti-piracy treaty. Its purpose was to provide protection against piracy of program-carrying signals transmitted by telecommunication satellites. Like the Phonograms Convention, it is very flexible. It leaves contracting parties the freedom to choose the legal means through which protection is granted. So that brings me to my amendments. I have drafted a number of amendments that, as I said, address the main problems. So my main amendment is, let's just replace these minimum rights by a single provision. Each contracting state undertakes to afford adequate and effective protection to broadcasting organizations against acts of unauthorized retransmission and perhaps fixation, if that really needs to be included. We'll talk about that later. Of their program carrying signals by means of one or more of the following: copyright, related rights, that's neighboring rights, or other specific rights, unfair competition, misappropriation, telecommunications law and regulations, penal sanctions, or administrative measure. And that is indeed a very flexible provision. The advantages of this approach, this more minimalistic, flexible approach, are obvious. First of all, this language is much more proportional since it focuses on combating piracy, on achieving the sole aim of the draft convention, which is to protect broadcasters against signal piracy. We avoid creating a new layer of special rights on top of copyright and other existing content-oriented regimes, which might otherwise easily lead to overprotection. We would greatly simplify this whole instrument. We could do away with maybe half of the text. Very flexible. Contracting states can implement the way they see fit. So that makes it much easier to implement as well. Since this approach reflects much better than the current draft the bare consensus that we now have within the SCCR, there's actually a chance of getting this treaty in the books. Then I have a couple of minor amendments, although they do address a couple of important issues as well. One is definitional. Should we or should we not include webcasting? What about these post-fixation rights? We don't want them, but maybe they're still there. And finally, limitations and exceptions. First, the definition of broadcasting. Now, in the old days, we could recognize a broadcaster from afar. You had a transmitter transmitting radio or television signals over the air to everyone at the same time. That was a broadcaster. But with the digitization, this has become much more difficult to actually clearly define a broadcaster and to distinguish what is a broadcaster from other types of content providers. How do we distinguish the BBC from Amazon Prime, from Netflix, from Spotify? You need really sharp definitions if you want to focus on granting protection solely to broadcasters and not to all these other players. And I think there's a consensus here that if we go along with this treaty, that we only want to protect real broadcasters and no one else. But the current definition and previous definitions in earlier drafts, in my opinion, do not clearly draw the line here. So we need some definitional help. So here's the definition of broadcasting that I propose as an amendment to the current Article 2A definition, which is in the third draft text. And the added language is underlined. First and foremost, what the current definition lacks is that broadcasting is defined as an act of transmitting content simultaneously to a general public. This was self-evident in the old days of broadcasting, but with all the modern technology and all the on-demand services, it's become much less self-evident, and it's not in the current definition. It is in many definitions of broadcasting, in many broadcasting laws around the world, but it's not in the definition. If we add that, there go the Netflixes. And another way of more finely distinguishing broadcasters from other content providers is by introducing a provision that the programs are provided in a pre-scheduled and linear order. There has to be a program, and that program has to have a certain order. Again, distinguishing broadcasting from other forms of online content providing. In fact, the latter part, the linearity, is already in the definition of broadcasting organization. In the third draft, I propose to take it out there and put it actually up front in the definition of broadcasting. This is what the broadcasting organization definition would be. In combination with the broadcasting definition, it becomes quite certain that we're really focusing on those players, the traditional broadcasters, that we want to grant protection against signal piracy. Another controversial issue, and it's been dominating the agenda for many years, is should we include webcasters? This is not the same as the discussion that I just mentioned concerning the Netflixes. This is a more general question about whether we want to allow broadcasters that solely use the internet as their transmission infrastructure to be protected by this treaty. In the old days, of course, this was a non-issue, but with the internet, we can all become a broadcaster by using webcasting technology. There are hundreds of thousands of radio stations out there on the internet that broadcast in that manner. Do we want to grant them protection or not? The opinions are sort of evenly split on that. There are many who say, no, let's focus on the traditional broadcaster, the terrestrial broadcaster. Others say yes, but even the traditional broadcaster nowadays uses digital technology, and in many cases broadcasts via the internet infrastructure. For example, in my own country, and we actually switched off broadcast TV from the airwaves. It's all internet or cable based. So how do we manage this? Well, in the first revised draft a couple of years ago, webcasting was effectively excluded. The second revised draft allowed the webcasters back in, but there was a reservation clause which contracting states could invoke in case they didn't want to protect webcasters. And now in the third revised draft, we see a somewhat watered down reservation clause where the contracting states can still leave webcasters unprotected, but in case of a broadcaster that simultaneously broadcasts over the air, the reservation will not have the effect in respect of such broadcasters. So a broadcaster that is both a webcaster and a traditional over-the-air broadcaster will always be protected. I think this is a bit of a muddled compromise. I would suggest to reinstate the language of the second revised draft, but this is really a political decision. My personal opinion is that digital technology has evolved in such a way that excluding internet-based broadcasting altogether is almost like throwing the baby away with the bathwater, because I can't actually imagine in the near future broadcasting to occur without any use of the internet. I don't see that happening. But if a contracting state wants to reserve the rights in that respect, I think it should be possible. My amendment here is, let's just restore the much clearer reservation possibility of the second draft. That brings me to the issue of fixation and post-fixation rights. The consensus is that this treaty should not extend beyond fixation of the signal. That's what's meant with no post-fixation rights. It's a 2007 General Assembly decision, was reiterated by the chair after the most recent meeting of the SCCR. Logically, that would mean no exclusive right of fixation, because a fixation right by necessity creates rights post-fixation. But despite the fact that the first revised draft, 2022, did not provide for a fixation right, it is there in the second and in the third drafts. And it's a rather ambiguous right, as it is proposed in Article 7. On the one hand, if we look at the explanatory notes, the chair repeats that this is not a post-fixation right, that the right basically ends at the moment of fixation. But then if you think about that, what kind of right is that if it doesn't have any effect post-fixation? It must have a post-fixation effect, otherwise it's not an exclusive right of fixation. So what kind of right is that? In any case, again, this is a controversial issue, and the broadcasters clearly want it. Probably they want it because they want it as an instrument to control acts of unauthorized retransmission. If that is the more narrow aim of the fixation right, I have some sympathy for it. But if it is actually a right that creates leverage for acts of exploitation following the initial act of fixation, I do not, because the aim of this treaty is not to provide for exploitation rights that go beyond retransmission. This is a piracy treaty. It is not a treaty that's supposed to be granting extensive rights of secondary exploitation. It's not a right we're granting to broadcasters to control aftermarkets in their broadcast signal. Right holders would never accept that, nor would civil society. So my proposal here is either to come up with a very narrow fixation right that clearly states that it's for the sole purposes of controlling the retransmission of signals to the public. So it's part, in other words, of the retransmission right, or do away with it, delete Article 7, and we have put an end to those discussions. I think both are acceptable. Then there's Article 8, which is a strange bird in the whole proposal. It came rather late to the table, obviously proposed by the broadcasters lobby, a right to control access and retransmission of stored programs, a right to protect the databases that contain the catch-up programs against pilfering, against piratic behavior. Obviously, this reflects what broadcasters, and particularly public broadcasters, have been doing all over the world in recent years, making their programs available usually for a couple of days or weeks in their catch-up services. And Article 8 purports to protect those databases against piracy. Well, I can understand that wish, but what we're looking at here is a blatant example of a post-fixation right. These, if the consensus is that the protection should go no further than acts of retransmission, which are defined, by the way, in the proposal as simultaneous retransmission, then this right has no place in this treaty. Again, a narrow treaty aimed at protecting broadcasters against signal piracy. That's not the same as protecting broadcasters in all their interests. If we grant this right to broadcast, I see no reason why we should not do the same for Netflix, for Amazon Prime, and other big providers of audiovisual on-demand services, because that's where the competition is. The catch-up services are basically on-demand audiovisual services. So get rid of this right, I would propose. Finally, limitations and exceptions. Again, another controversial part of the proposal. There has been a lot of discussion about whether or not the limitations and exceptions provided in current Article 11 aren't too narrow, aren't too traditional. There's some progress here. The third draft makes it clear that the examples of permitted limitations and exceptions in the draft are non-exhaustive. The words "such as" have been added to the enumeration, which is an important step forward. What that means is that contracting states may also provide for other exceptions beyond the examples given in current Article 11.1. Nevertheless, the current draft, in my opinion, remains too narrow because it mentions specific limitations and exceptions. The word specific suggests that only narrowly crafted exceptions would be allowed under this rule. And this, of course, is problematic, not so much for countries of the European tradition that are used to narrowly crafting exceptions and limitations, but for countries like the United States, where the general doctrine of fair use is very unspecific and very much determined by judicial interpretation. Fair use rule is not a specific exception. Does that mean fair use cannot apply here? I don't think that's what is intended, but it would be good to make it clear that fair use type of exceptions or fair dealing type of exceptions, as we have them in many other countries of the formerly British copyright tradition, that they are allowed under this rule. So get rid of specific would be another amendment. And then there's another issue, and this brings us back to the risk of overlap and overprotection, which is constantly hovering over this treaty which is framed as establishing a new layer of rights on top of content already protected by copyright, and in some cases, neighboring rights. The rights in the content being broadcast by the broadcasters. On top of the content-oriented rights, a layer of signal-related rights. And that bears the risk of incompatibility of exceptions. If a contracting state would implement this special right for broadcasters in a way that it would allow for fewer exceptions than the existing exceptions under copyright and neighboring rights law, the net result would be that someone who wants to invoke these exceptions based on content accessed through a broadcast signal would be stuck with this much narrower set of exceptions. In other words, limitations and exceptions could be undermined by this new layer of rights unless it is guaranteed that the new layer of rights is introduced together with all the exceptions and limitations that already apply under copyright and related rights in respect of the broadcast content. Finally, I believe that the three-step test, which is another staple article of any IP treaty these days, is not appropriate, since this treaty is not an IP rights treaty. That brings me to my last couple of amendments. Delete specific. Make sure that in Article 11.2, contracting parties shall, not may, but shall in their national legislation provide for the same limitations to this broadcaster's right as they already apply in respect of the underlying content under copyright. And delete Article 11.3, which mandates the three-step test. Last amendment, I know the chair doesn't like it, and doesn't want another set of agreed statements as we have them accompanying the WIPO copyright treaty and the WPPT of 1996. But why is it not here? Article 11, in my opinion, should be illustrated by an agreed statement very much in line with what we already agreed upon in 1996, stating that in the digital environment, we are allowed to carry forward existing limitations and exceptions that we consider acceptable under the old treaties. Why not here?